All right. Now, I'd like to discuss the importance of updating your legal documents as you age. You know, couples get divorced, family conflicts arise, and health issues can occur over time, especially cognitive-related diseases such as Alzheimer's disease and estate planning, financial issues all change over time. Well, there's a lot to know. And let's bring in Notary Christina Kadas to help us out. Maitre Kadas, welcome to Life Unrehearsed.
Hello, thank you very much.
Well, thank you for joining me here on a Sunday, Maitre Kadas. So many important questions. Let's get right into it. And we're going to start with wills. Over 50% of Canadians still do not have a will. Why is it important to have a will?
It's very important to have a will because you want to ensure that if ever something happens to you, that your wishes are carried out so that you decide and you have control over how your assets are divided and also who's going to be administering those assets in order to carry out those wishes. So if you don't have a will, then it's up to the Civil Code of Quebec to decide who inherits from you and in what proportion they're going to be inheriting.
Yeah, and you know, I think when I talk to people, as I'm sure you do, Maitre Kadas, you really don't want the government to be handling those huge, important decisions. So no reason not to be able to do a will and get your wishes said in advance.
Yes.
All right, we're going to switch gears, Maitre Kadas, to a question I get a lot. We tend to think of, I've got a power of attorney, or I better get a power of attorney, and everything will be solved if I have one. But I'd like you to explain the difference, if you could, between a power of attorney and protection mandate.
That's a very good question. So a power of attorney is valid when you yourself are still capable of making decisions for yourself, but you're choosing not to make those decisions. For example, power of attorneys could be useful if someone travels often, or even as a person ages. Well, they may still have the ability to make their own decisions, but they may not want to have to handle all of that on their own. So maybe they're no longer driving, maybe they no longer see well, or they no longer hear well, and would just be easier if someone else were able to handle those affairs on their behalf. So that's the situation where a power of attorney would be useful. It's where you still have the ability to make your own decisions, but you're choosing not to. Now, the difference between the power of attorney and the mandate, the protection mandate, is that in the case of a protection mandate, you're no longer able to make your own decisions. So protection mandate is used when we're talking more of a cognitive impairment or a inability to make your own decisions. So if a person, for example, has a physical incapacity, then we would not be using a protection mandate. We would be using a power of attorney. So for the protection mandate, it's really an inability to understand and to be able to make your own decisions.
Listening to Life Unrehearsed, Matt Delvecchio here, and I'm talking to Notary Christina Kadas about the importance of updating our legal documents. All right, Maitre Kadas. So the protection mandate is while you are apt, you are saying if ever I become inapt, now I'm assigning as a mandatory someone of your choice. So a lot of people that I talk to said, I'm good. I've got the protection mandate, no worries. What a lot of people don't realize is that you actually have to execute that if ever you do become inapt. The fancy legal term is called homologation. Can you explain to our listeners, Maitre Kadas, what does homologation mean?
Correct. So that's a very good question as well. So protection mandate, as you mentioned, is a document that you would sign in advance once you're still capable, and you would say, if ever I am unable to make decisions, this is who I'm choosing to make my decisions for me. But the question about whether a person is in that state of incapacity and whether the protection mandate has to be used, that incapacity has to be proven. So that's the process of homologation. Homologation is essentially the process where you're enforcing the protection mandate. So there's a court procedure that has to be completed, a medical assessment has to be completed, a psychosocial assessment has to be completed by a social worker to confirm that the person is not able to make their own decisions, because we cannot just assume that someone is no longer in a position to make their own decisions. This has to be proven by professionals. So the homologation process begins with the assessments and then continues with a legal procedure. Ultimately, at the end of the legal procedure, a judgment is rendered by the court confirming that the mandate is in effect and that the person that was appointed in the mandate is now making the legal decisions for the person that is incapable.
All right. It makes a lot of sense what you're explaining. And I'm glad you clarified that just because you have a protection mandate, which is highly encouraged, if ever you need to execute it, it's just not a matter of saying, do it. There's a process involved, could take several months, and that's called the homologation process. All right. I want to give you a scenario here, Maitre Kadas, where a couple wants to sell their house, and I've seen this many times, and it's very concerning. One of the two has been diagnosed with dementia for several years now. Can they sell the house with only having a power of attorney in place?
So if the person is, because a diagnosis of incapacity, sometimes the person is not totally incapable yet, but in our example, let's assume that the person is in a state of incapacity and does not understand what is going on and would not be able to negotiate the terms of the sale, sign the deed of sale at the notary. In that case, a power of attorney would normally not be sufficient. So in that particular situation, the family should see if the person signed a protection mandate and have the protection mandate homologated to give the right to the person that wants to represent them to sell the property. Because in most cases, just with a power of attorney, they would probably be stuck and go through certain roadblocks to be able to go through with the sale of the property. And it's also important to mention that the homologation process can take quite a bit of time. So if you are in that situation and you're planning on selling a property, it is a good idea to start working on this way in advance, because by the time we receive the assessments, by the time the court procedure is completed, it could take several months, even a year sometimes, to have everything put into place.
Very important to know, especially if you need the funds from that asset. Maitre Kadas, we're already out of time. I want to thank you very much. How can our listeners get a hold of you?
So they can reach me directly at 514-505-4060, or they can visit our website at christinakadas.com.
Great. And that's Kadas, Kadas, correct?
Correct.
All right. Well, thank you very much for joining us here and providing some great information.
Thank you for the invitation.
All right. You're most welcome. That's Maitre Christina Kadas. She's a notary and obviously very well attuned. And if you have any questions, feel free to reach out. Obviously, important legal documents that we all need to be aware of as we age.